who would put the account executive who had handled the loan together with a workout executive on the workout and would be doing it for the long haul. They had been lenders to the company and they stuck with the company and they tried to recover their investment and they like to see the company survive, and they clearly wanted to get back the par investment they made. The modern lender, the non-traditional lender, you may see an old line lender as the agent. They're not going to have much money in the game. They syndicate and participate out most everything. They tend to be in it for fees as opposed to principal and interest. And replacing them are the hedge and equity funds who have most of the economic exposure and often buy into the syndicate in discounted, sometimes deeply discounted ways. And their economic motivations often are not necessarily limited to par. They are not necessarily limited to, I'll do better in a going concern. Sometimes their investment is so low that a liquidation is far better for their return on their investment than a continuity of the business. The other pressure point that comes to bear in the new modern Chapter 11 world is the dilemma of, and it's been around since over 10 years now, is the 120-day exclusivity period for the company to file its plan of reorganization. It could be extended all the way up to 18 months, and that's it. So it has an 18-month max window to be in charge. However, in your retail cases, you don't even have that much time, because in the retail cases, you only have 120 days initially where you can decide what you want to do with the leases. You can extend it. Almost everybody gets it extended for an additional 90 days. And thus you have 210 days to control your leases. But in reality, you don't even have that much. Jennifer?
Yeah, and just to add to the point that Scott's making, as a result of these shorter time frames, companies no longer have the luxury of entering bankruptcy and then working out what they're going to do with their business plan or what their strategy is. So you're seeing more often than not now a lot of what's called prepackaged plans, or sometimes pre-negotiated plans, where the major constituencies are on board with a plan, and then they enter the bankruptcy case and basically have to then solicit the vote and get that plan, that strategy through. And of course, this is a detriment very often to, in particular, retailers that may want to enter bankruptcy, not just for a balance sheet restructuring, but in an attempt to test out a new operational or business plan. Traditionally, Scott and I have been in a lot of cases that had the luxury of testing out a new operational business plan over the course of certainly one Christmas holiday cycle, but very often two holiday cycles. That's no longer the case, and that's not the luxury that retailers are afforded. So it's definitely detrimental to those businesses that are attempting to not just do the balance sheet restructuring, but implement a new business strategy.
And that's why each of you in your world, in particularly looking at retailers, have very few of them that have come in and out of a Chapter 11 intact. Clearly, that is now the absolute exception to the rule, because among other things, the lender, and I remember when this first came about, and we thought this particular lender, who is no longer in the lending business, was crazy, but it turned out that that lender was simply ahead of the curve. That lender said, this is early in the modern bankruptcy code, that lender said to its borrower, its debtor in possession, you have 90 days. I know the statute says you could have 18 months to do a plan. I know you can deal with leases for up to 210 days or 7 months. I'm giving you 90 days. That's all you have. Unless in the 90 days you can fix this business, sell this business, show me an operational exit for this business, you must liquidate. And the reason that lender did that was, and it required the debtor within 90 days to file with the bankruptcy court a pleading saying, Judge, give me an order in the next few weeks, or let's say within the first 120 days, permitting me to liquidate all my assets, because the debtor needs, the lender needs 2 to 3 months, sometimes a little less, but they can't get more, to liquidate the inventory in the stores on site. And so the lender is looking forward saying, okay, at the end of 90 days, you got to fish or cut bait. Because if you don't fish or cut bait at the end of 90 days, I want you liquidated, because I want the inventory liquidated in the stores, because the liquidators will pay the rent and I will get the maximum return on the inventory, and we have to be out of those stores at the end of 210 days. And so the retailers are coming into bankruptcy either with an absolute certainty of the stores they want to close, or a very short leash to make that determination. And where they can, they try to construct, and we've seen a few of these, the entire exit strategy before they come into bankruptcy, often with one of the hedge or equity funds as the owner of the secured debt and the owner of the equity, agreeing to an exit strategy with a very quick turn of the Chapter 11, because otherwise, at the end of 90 days, these lenders want to see their assets liquidated for a recovery while they still have the leases and before they have the requirement to reject the lease or to assume the lease. Now, what assets are there, as availability of assets slide suggests? Well, it's not uncommon to find the assets, certainly in a large case, pledged more than once. Intercreditor agreements have become a very popular subject for bankruptcy judges to rule on. They're getting ruled on more often than I would ever have anticipated, primarily because of provisions concerning what's known as make-whole premiums, or and there are other terms, or just premiums. There are other terms for these additional funds that the lenders say they're entitled to if the loan breaks before its maturity. And so you're finding more and more of the larger cases where the inventory and all other liquid and fixed assets are encumbered multiple times. Sometimes the ABL, the asset-based lender, will have a lien on the liquid assets, the accounts and the inventory, and the term lenders, usually hedge or equity funds, have a lien on the fixed assets, maybe the intellectual property. However, they have an intercreditor agreement where each has a lien on the other's assets. But bottom line is, for you, you're back to your cash flow credit check. There are no assets for the general unsecured creditors, with some very limited exceptions. Jen?
Yeah, and that exception is what's referred to as Chapter 5 avoidance actions, which some of you may be familiar with. Preference actions, where a debtor may seek to recover payments made in the 90 days prior to a bankruptcy filing. Very often, that is the only unencumbered asset pre-petition, but even then, once the bankruptcy case files, when the debtor is giving out adequate protection liens, lenders will try to get the avoidance actions covered by the adequate protection liens. And that is then often a fight with creditors, or in all likelihood a creditors committee, to at least get that one asset unencumbered, so it's for the benefit of the general unsecured creditors. There's a little bit of a catch-22 there, which Scott's going to be talking about in a moment, because very often, if there is no actual cash recovery on your claim, you at least want a release of preference action. So in one instance, you're fighting to get for the one unencumbered asset the preference actions, but you may not want to actually pursue those preference actions for the benefit of creditors. And that leads into Scott's next point.
Well, on that point, it's very important to know who your customer is. It's very important to know where the assets are. And an example of that certainly was and still is Kmart and Sears. When Kmart went into bankruptcy, as I said, the inventory was unencumbered, but and we represented the creditors committee, at least the general unsecured creditors committee, most people did not actually know based upon the kind of funky documents Kmart was then using. By the way, it was the same thing in Macy's, but a little less crazy, based upon the vendor book and the documents that were flitting around. Most people did not know who they actually were selling to. And in the modern Sears Kmart, you know, the case that, or the company that never seems to get off the front page, it becomes relevant again, but unfortunately it's becoming less relevant to know who you are selling to and where the assets are. So for instance, the intellectual property assets, which sometimes are unencumbered in these bankruptcies as well, or they're not properly perfected, and sometimes leases aren't properly perfected. In the Kmart Sears case, they have tremendous intellectual property. As everybody who has dealings with them or reads papers knows, they're looking to once again liquidate assets, and they're looking to figure out who might want to buy, and I use the word buy loosely for the moment, the Kenmore and related powerful Sears labels. And the problem with the realization of that value is they have pledged those assets to the Pension Benefit Guaranty Corporation to secure massive shortfalls in the Sears pension. So what is your availability of assets? You have to know who your borrower is, who your customer is, and where those assets are, because they're few and far between. But if they're not in your borrower, they're useless to you. I say borrower, your customer. Changing goals for bankruptcy. So when I started doing this, everybody wanted 100 cents on the dollar. Everybody analyzed the inventory, what we could realize the inventory, what we could realize on the receivables. That was the main thrust. A lot of companies stayed in business. The small companies, the equity owners wanted to retain the business, and getting less than 50 cents on a dollar, 60 cents, 70 cents happened, but those were not unrealistic targets in many of the old line bankruptcies. The new bankruptcies, you don't have any unencumbered assets to speak of. The lenders often come up short. And so it is not often, does happen occasionally, that you could be looking at large recoveries for the unsecured creditors. So what are the goals for the modern bankruptcy? They have changed. One goal is, well, I'd like to retain the customer because if it's a cleaned up balance sheet after a bankruptcy, possibly with new working capital, possibly with new owners with brighter ideas, I make money, in theory, on every item I sell, assuming it gets paid. And so retaining the customer as a recovery item is far more important. It was always important, but today it's far more important. Jen talked about preference actions. Modern bankruptcy, one of the goals of a creditors committee, which is reasonably well represented, is, okay, the last thing we want to see is a liquidation, everybody gets sued on preferences. Now, sometimes that can't be avoided, but one of the goals of the modern bankruptcy for a creditors committee that is at least a vendor-dominated committee, maybe not a bondholder-dominated committee, is how do we avoid the preference actions so we don't have to give back money, no less not get any money. And there are several ways in which each of us have tried to deal with preference actions. Besides my old belief that the preference laws just simply ought to be abolished because they've lost their way in life, but several ways of avoiding the preference actions. When we sell the business or assets, we often approach the buyer, if the buyer hasn't already approached us, and have said to the buyer, buy the preference actions because you don't want the liquidating estate to sue the vendors who you will be seeking goods from. And sometimes the buyers buy the preference actions, and sometimes they agree not to prosecute them. That's one way. Sometimes we've allowed the lenders to take a lien on the avoidance actions with the agreement that they'll never prosecute the avoidance actions. But in both those instances, you have to be prepared to say to the court what the value of the avoidance actions are, or have some sense that the estate is getting something for what it's seeking to give up. A third way we've gotten rid of preferences, a hard way, is we abandon them, or as part of a dismissal they get abandoned on the theory that there's no money to pursue, they will not go anywhere if they are recovered back. It's cannibalizing, each creditor is cannibalizing each creditor, each other. That is a very difficult one to accomplish. So we try to get rid of them by selling them to the buyer, having the lender take them, or somehow in a plan of reorganization, if it's a consensual plan, releasing them under the plan. And there again, you have to set forth, are you really giving up any value? But that has now become a goal of a Chapter 11. It wasn't a goal 20 years ago or longer. A goal in bankruptcy, and all of you who are reasonably exposed to the bankruptcy world know this, is how do I become a critical vendor? How can I sneak in under that order that often the debtors get early in the case to pay certain limited universes of creditors in full, in exchange for which the debtor almost always asks for receipt of normal credit terms back. So if they give you 100, they want 100. Sometimes they say they'll give you 100 and they'll give you it in 4 installments, but you have to give them 100 back immediately. That's not a good deal. But the point is, becoming a critical vendor is extremely important in the modern bankruptcy, because it's one of the few ways in which you can get your pre-petition claim paid. And yes, you're now exposed as a post-petition Chapter 11 creditor. At least at that level in the food chain, you have a better shot at getting paid than the unsecured creditors. There was an instance in Kmart where the court in the Seventh Circuit, Judge Sondeby, permitted $360 or $70 million of critical vendor payments. There's never been a case with that magnitude, but the circuit court, the court all the way up, reversed it, and that occurred under strange circumstances, and the reversal caused Eddie Lampert, when he took over control, to go to all the vendors and use it as currency to say, I won't seek recoveries from you, even though the circuit reversed and said you should all give back the money, but he used it as currency to get better credit terms. But today, even that courthouse enters critical vendor orders based upon the proper record before the court. PACA or PASA rights have always been there, always is a long time, but for decades, that protects the growers, Perishable Agricultural Commodity Act, and PASA is a similar state law, and it protects people who grow. It's a farmer kind of relief, and it was never as emphatically pursued 20 years ago as it is today, because they come ahead of everybody, and with no unencumbered assets left, they run into the courthouse in a heartbeat if the debtor on the first day of the case has not otherwise sought an order of the court, getting them paid. Next slide. DIP issues. This affects you to your customer. It affects the lender. And it all comes about because of the modern Chapter 11. And you should be thinking about this as you check credit, because there are things that happen on the first day of a case that it's too late for you to think about, but you may be able to anticipate it with certain of your accounts. So the DIP lender, the debtor in possession lender, is faced with the modern bankruptcy issue that people who have sold goods that were received by the debtor within 20 days are theoretically entitled to be paid the value of those goods, even though they were shipped pre-petition. Sometimes you can't get that payment at the outset of the case. Sometimes you can't even get it at the end of the case. The lender, however, says, I'm not sure what's going to happen on that. So when they put the DIP loan in, they provide either reserves or they require the cash flows to reflect payment out. But bottom line, it limits the amount of money that the debtor has for new Chapter 11 purchases. Similarly, because of the activity of PACA and PASA, the lender says, well, you're going to have to pay out those guys. So I am going to reserve, or we're going to impose in your cash flows the cost of PACA PASA. All of this is affecting your availability from the lender to the customer that you want to sell to during the Chapter 11 critical vendors that I just spoke about, the debtor usually tells the lender before the bankruptcy, I'm going to go in with a $1 million program or a $2 million program. Hopefully the judge will in fact authorize the grant of the relief, and the lender says, okay, I'm going to impose $1 million in my hypothetical reserve for your availability, therefore less money in the Chapter 11 to pay Chapter 11 credit extensions, or it'll impact on the cash flow, and therefore less availability to pay for your goods that you're sending into a Chapter 11. Stub rent, another modern problem, because every retailer always used to file on January 2nd after the Christmas holiday season, either when they pay down the bank line, those are the good old days, or now at least they reduce the bank line and have some availability. But the landlords are very aggressive in this country out of necessity, because if there's a filing on the 2nd of January and the rent was due on the 1st, are they or are not they entitled to get rent for the balance of January? Different jurisdictions treat it differently, but the lender says, I have to reserve or impact the cash flows because you may have to pay out the rent for the hypothetical January to the end of January. The other two things that are impacting upon, if you will, the dip, but more impact upon you, which is I would call an off-balance sheet item that you need to be concerned about, because it's not always accurately reflected, and it's almost never reflected in the amounts the PBGC believes is the underfunded pension liability. I don't think I've ever seen a case where there is an underfunded pension where the PBGC and the debtor are within zillions of dollars of each other as to what the underfunded pension liability is. And it usually is a contested matter in the bankruptcy, but you're checking against a balance sheet that has no assets and has more liabilities than you realize, because that also includes WARN Act claims. They are extremely aggressive because they know unless they can assert and get paid for the last 60 days or the next 60 days on some sort of priority basis, because wages get priority treatment up to certain levels and for certain periods of time, they're never going to see anything as an unsecured creditor. And so the WARN Act claimants are very vocal and very visible almost on the first day of the case. And then on top of that, as I said, you have the shorter time frames imposed by the lenders to fix all these problems. Otherwise, you have a liquidation. And so the bottom line for a modern bankruptcy case is you need to be more cautious. You need to be more cash flow oriented. You can't rely on the assets on the balance sheet because they're usually understated. They're overstated in value. And you have certain types of claims that you need to figure out how to grab onto, whether it's 503b9 20-day goods, critical vendor, PACA PASA, stub rent. Well, I assume you're not employees on the phone, but you have to be more aggressive in the bankruptcy than you ever were before, and you need to be more considerate of the absence of assets as you're checking credit on these customers. Sam, that's about our 30 minutes. Open it for questions. I know you have the floor for another 5 or so minutes.
All right, let me take you off speaker 1 second. All right, we do have some questions here, Scott, so hold on a second and let me get to them. All right. Well, first of all, Scott, thank you and Jennifer very much for the information that you shared. All right, and let me go in here and look at the first question. All right. All right, so Scott, first question is, preference actions were supposed to benefit the unsecured creditors. We are getting hit with actions on most cases whereby everybody received money in the normal course and we have to defend our position at high cost to eventually settle with the trustee. We never seem to recoup anything on our claim after all these preference actions. The money just seems to be going into the pockets of the attorneys. Lousy rule. That is from Gary. I don't know if that's a question or a statement, but I don't know. You want to address that, Scott?
Sure. Gary is absolutely 110% accurate. I said preference laws ought to be abolished. They should be. They were designed to grab the creditor who got a whisper from the CFO that we're filing bankruptcy, and they extort money, or they put a gun to the head of the president of the company. It, however, has become a weapon against a credit executive, a credit professional doing their job, and it's rare. It happens where the money goes back to the unsecureds, but it first gets used to pay the Chapter 11 items, and as Jennifer touched upon, avoidance actions often are grabbed by the lenders, whether they get it as a lien or they get it as an adequate protection. They often grab it before even the professionals can grab it. It's a bad law. The ABI was proposing certain changes, but nothing terrific.
All right, so I have a question from Tom. Should I ask for some type of documentation to support a critical vendor agreement before approving future shipments?
Let's assume you're a pre-petition, you're concerned about the account, you could document it up the wazoo. You can say, and we have suggested these things to clients, that you get pieces of paper that describe you. The customer admits you are the most important thing since marbles, and that they will seek to have you classified as a critical vendor if and when they go into bankruptcy. It is not particularly meaningful. You cannot go to the bank on it. It may help to a 1 or 2% extent when they file and when they seek a critical vendor, to say the XYZ company is a critical vendor. We and they agreed they were a critical vendor. See Exhibit 1. But there's no guarantee that a court will allow the critical vendor program. There's no guarantee the debtor will actually honor that. And so you could try to do that. However, it has no teeth associated with it.
All right. Well, are there any other questions from any other members, participants? I see that that was only had 3 questions, and those are the 3. So it is now 2:37, and so given the fact there's no other questions, I'd like to thank everybody for taking the time to attend the webinar. We recorded this webinar, and we'll have it available on our website next week. If you have any questions, Scott and Jennifer's contact information. Scott, if you scroll to the first page on the presentation, and what we'll also do is post a link to the PowerPoint slides. If you want a copy of the PowerPoint slides, just reach out to us directly. But once again, I'd like to thank Scott and Jennifer for taking the time out of their day to join us, and thank you very much to the audience. Any other questions, you can always contact me, Sam Fensterstock, at samf@agaltd.com. And I thank you very much for attending. Have a fantastic afternoon. Thank you, Scott. Thank you, Jennifer.
Okay. Bye-bye.